Charities are public, therefore, both being enforced by the Attorney General and publicly supervised. They also enjoy various rates and tax advantages. As we've seen in Dingle and Turner, Lord Cross bemoaned that the same test applied for both validity and the various public advantages, including tax, that charities enjoy. There are, however, other consequences that follow from the public nature of charities. The first is that you have to ask two tests. First of all, is there a general benefit? And secondly, is there an additional public benefit? Only if you have both of these will a purpose be regarded as charitable. We now consider the sources of charities law. Until the Charities Act 2006, there was no statutory definition of charity. And the best that we could do statutorily was to consider the preamble to the Statute of Charitable Uses 1601. Now, of course, preambles do not have any general force, but the preamble was regarded by the courts as being the basis for the modern law of charities. Then in 1891, the Commissioners of Special Income Tax against Pemsel, the House of Lords laid down a definition of charitable categories. 4 categories of charitable purpose were laid down in the Pemsel case, and a 5th, as we shall see, was added by the Recreational Charities Act 1958. Now, the Charities Act 2006, which is coming into force this year in 2008, lays down for the first time a full and comprehensive statutory definition of charity law. However, it adopts the existing law as its basis, and probably as a codification, an amplification, rather than an attempt generally to change the law. There has also been, since 1960, a registration procedure for charities, and registration, or refusal to register, is conclusive unless the registration itself is challenged. So in many cases, there's going to be no question about a trust going to the courts on the basis of whether it is charitable or not. However, sometimes the registration is challenged, as happened in the Incorporated Council of Law reporting case, and indeed in McGovern and Attorney General, a case that we'll look at later concerning the purposes of Amnesty International. Now, the Charities Act 2006 sets out the categories of charitable purpose. The categories are set out in section 2, and they are, as I say, an elaboration on rather than a change, I think, to the common law that had been developed in Pemsel and in the Recreational Charities Act 1958. There is also quite clearly, in section 2.1, the retention of the superadded public benefit element to charity. And section 3, which we'll look at a little bit later, then elaborates on the idea of public benefit. It is possible that that there's been a change to the law in public benefit, in that public benefit is no longer presumed to exist and must be proved in the case of any charitable purpose. The 4 heads in Pemsel, then, are the relief of poverty, the advancement of education, the advancement of religion, and other purposes which are beneficial to the community. These heads were effectively a judicial codification of the law that had been developed in the cases prior to 1891. Because the 4th head was regarded by the courts as rather narrow, as we will see in the 1950s, the Recreational Charities Act of 1958 added a 5th head. And in addition to that, there is, as I've already said, a superadded public benefit requirement for charity. And that up to now has basically been the way in which charities have been defined. If you look at the Charities Act 2006, section 2, you will see that listed there in the Act are the first 3 of the heads from Pemsel: the relief of poverty, the advancement of education, and the advancement of religion. There is also, later in section 2, other purposes that are recognised as charitable or are in the spirit of purposes currently recognised as charitable. Therefore, the fourth, and I would say that the fifth heads in Pemsel and in the Recreational Charities Act 1958 remain expressly part of the law under the 2006 Act. There is then, also in Section 2 of the Charities Act 2006, the setting out of specific charitable purposes, as you can see in the PowerPoint. These are essentially codifications of what was already in Heads 4 and 5, and I suppose it is a clarification of that. It may also be that to some extent there is a slight extension of the purposes that were already regarded as charitable, though I do not see that the Charities Act 2006 should be regarded really as changing the law, more as simply clarifying it and putting it onto a statutory footing. Section 3 sets out the public benefit requirement, and as you can see from subsection 3, it is essentially a codification of the existing law of charities. However, in subsection 2 there is no longer a presumption that a purpose of a particular description is for the public benefit. Now, I'm not entirely certain what the effect of this is. The only head for which there was clearly a presumption of public benefit in the past was the poverty head. However, it is clear that the Charity Commission take the view that public benefit is also presumed, or has been until now, for the education and religion heads. Now, this is not my reading of the law. We'll come back to this later in the course, but it is one of the things that informs the present debate, very strange debate, on the public benefit of independent schools. As I say, we'll return to this area later.